as we start. Any question? No question. All right. So I want us to start from where we left. Guys, I don't know why you guys don't have questions, but essentially you should be having questions. Unless you guys don't want to read, or something is just not making sense. Okay. But okay, fine. Let's get with it. So in the last class we talked about probate, and that is last Friday. And in that class, I remember I did indicate that whenever you talk about wills, there are things you need to consider. That is a question of making a valid wills, everything that goes into a valid will. And we did say that a will is divided, the validity of wills will be divided into three, okay? The question as to what is valid or invalid will be divided into three, okay? The first one is the question of capacity that we did discuss in the last class, capacity. So in as far as capacity, umelewa mapema sana bwana. It's just 7. You're drinking too early, my friend. Ngoja kwanza ifike 12. All right. So I said that the first thing that goes into the validity of wills, anytime you're told to discuss the validity of a specific will in a question, then you go and look at the question of capacity that touches on age and also the mental status. And that is the case of, what is the case that we discussed? Banks versus Goodfellow. All right. So in the case of Banks versus Goodfellow, the court now establishes the factor that must be considered whenever somebody is assessing the mental capacity of the maker of the will. Now, we also talked about the question of formal requirements, which was generally from section 11, where we said that in terms of section 11, whenever you're making a will, it must be executed by the testator and it must be attested. And we talk about the question of attestation and execution in that sense. And then lastly, we talked about the vitiating factors, that these are the factors that could make a will become invalid, even though the will was properly made with clear capacity and properly executed and properly attested. And these are the things we called the vitiating factors. And some of them included certainty or uncertainty, undue influence, forgery, fraud, mistake, suspicious circumstance, and so on. So those are the factors we're calling the vitiating factors that vitiates the validity of a will, even though that will was made properly. Now, that was our discussion in the last class. Now, today, I want us to start from the question of revocation of wills. Now, we have seen how wills are made. Now, it is upon us to look at how the same will can be revoked. Okay, remember that under our general features, that is the features of a will, we did say and discuss that one of the features is that a will can always be revoked. A will can always be revoked, and for that reason, you need to understand that the same under section 5, section 5 provides for the testamentary freedom, and it says that any person can make a will. Now, the same provision provides that based on that testamentary freedom, you can revoke a will. Okay, you can revoke a will. So the same way you make a will, you have to revoke. You can revoke a will. You need to understand that bit very clear. But also make sure, okay, make sure that you understand that the requirements needed for the revocation of a will, for the making of the will, are the same requirement that are needed for the revocation of that will. Okay. For instance, the question of capacity. You make a will when you have the capacity, when you are above the age of 18 and your mental capacity is clear. Okay. Now, you can't revoke that will unless you are revoking it. Okay. Unless you're revoking it under the same condition. So if you lack capacity, you can't revoke a will. So for you to revoke a will, you must have the same capacity. Okay. Now we are going to discuss the various ways in which a will can be revoked. Okay. The various ways in which a will can be revoked. Now the first one is what you're calling the voluntary revocation. Voluntary revocation. And then involuntary revocation. Okay. Now voluntary, the express revocation, voluntary revocation is whereby the testator himself revokes the will voluntarily. The testator himself will revoke the will voluntarily. So that is what we're calling the voluntary revocation of wills. Are we together? Now, let us start. What is the first way in which a will can be revoked voluntarily? What is the first mode of revoking a will voluntarily? Somebody, you wanna come in, or should I just proceed and discuss them? All right. Sawa. Now, when you talk about voluntary revocation, then in that instance, we are talking about factors or actions of the testator that lead to the revocation of a specific will. So the first one, somebody's microphone is mute. All right. So the first one is making another will or codicil. So when you make another will in, when you're still alive, and in that will, there are two things that can happen. You indicate clearly, and normally it is indicated that all my previous wills and testamentary, testamentary gifts have been revoked. Okay, so normally the testator will indicate in the new will that all my previous wills and testamentary dispositions have been revoked. Are you together? So you can't revoke another will by making another will. So if you make a will in January, you can make another will in December to revoke the will in January. Okay, whereby you indicate specifically under this new will that all my previous wills are hereby revoked. Are we together? So that is the revocation by making of another will or codicil. Now remember that a codicil cannot revoke a will. Codicil cannot revoke the entire will. However, the codicil can revoke just part of the will. So unless that specific will is just composed of one part or one gift, then you can revoke it by a codicil. But a codicil normally just revokes or amends one specific part of the will. So not the entire part of the will can be revoked by a codicil. So that is what you ought to understand as well. Perfect. That is what you need to understand. You need to understand very much. All right. Now, once you understand that point, then we go to the next one. Okay. So the first way in which you can revoke a will is making another will or codicil. So if you give somebody something, you can revoke that gift by making another codicil. So remember, we have a will and a codicil. We have a will and a codicil. What is the effect, or what is the meaning of what I'm trying to say? I am trying to say that a will revoke another will. Okay. Number two, a codicil will revoke just part of the will. For instance, if you make a will and you give all your children, assuming that you have 15 children, like my uncle, You know, my uncle is very generous with kids. He's literally filling the earth single-handedly. You know, so right now he's already at 15 and he's still counting. So if you are like my uncle with 15 and you give everything to your children, and then 2 years down the line, one kid is not making you happy, you don't need to revoke the entire will. You can write a codicil to revoke the part that you gave to that errand boy. Are you together? So that is what I'm saying. So make sure you understand that. Make sure you understand that bit properly. Okay. So making another will or codicil. A codicil can only revoke part. A codicil can only revoke part of the will, while a will shall revoke an entire will. Any question? All right, that is okay. The next one that is under voluntary revocation, the next one that is under voluntary revocation is the question of destruction. Destruction. So a will can be revoked through destruction. Okay, a will can be revoked through destruction. Okay, when the word destruction comes to your mind, you need to remember the rule in Cheese versus Lovejoy, Jones, and the case of Sutherland. Okay, those are the cases that deal with the question to do with destruction. So what is destruction? Destruction is very simple. It's just an instance where you destroy. An instance where you destroy the will. Okay, you destroy the will. The will is destroyed. So there are various ways of destroying the will. You can burn the will, you can tear the will into parts, you can shred the will. So that is destruction. So what is the rule when it comes to destruction? Now there are two conditions that must be met for there to be revocation by destruction. The first one is all destructions in the world. All destruction in the world. That is the first one. The second one is all intentions in the world. There must be all intention in the world. Are we together? So what do we mean? Now, for you to conclude that this person revoked his will, okay? For you to conclude that this person actually revoked his will, then there are a few things that must be there. Okay? The first thing that must be there is the question to do with the actual destruction. There must be destruction. Okay. Number two, that destruction must be accompanied by the intention. So if there is no intention, then there is no revocation. So if you take your will and you burn it, okay, but you don't intend to revoke the will, then that will is not revoked. So for there to be actual revocation, there must be the intention to revoke it. Number two, the actual destruction. When it comes to actual destruction, what it actually means is that you must really mean the business. You must really mean the business of destroying that specific will. Are you together? You must actually destroy it like you meant the business. Okay, and that means that if it is burning, you burn it. You burn it until it is reduced to ashes. If it is the question of shredding, you have to shred it until you can't put it together. Okay, now what happened in the case of Cheese versus Lovejoy? Okay, so in Cheese versus Lovejoy, the testator made a will. The testator made a will. After making the will, the testator, give me a minute. After making the will, the testator, after some point, took the will and wrote on, on the front page and said all these are revoked. And then he tore the will into two pieces and then placed it in the kitchen table. Okay, he placed it in the kitchen table. Now that will stayed there for 7 years. And then When the person died, the question arose whether that will was actually destroyed or mean revoked or not. And the court said no, that will was never revoked. The will was never revoked. And why was it never revoked? It was never revoked because in as much as there was the intention, he intended to have the will revoked, but there was no actual destruction. So you taking the will and tearing into two does not mean anything. Okay, when you do that, it doesn't mean anything. Are you together? So tearing the will into two doesn't mean anything at all. That does not count as revocation. So you have to revoke it by actually revoking it. By the time you're destroying it, nothing should remain of that will. That is what the court said in the case of Cheese versus Lovejoy. So that is the case of Cheese versus Lovejoy. Cheese is just cheese. Cheese is just cheese, and then love is just love. Mapenzi too. Together. So Cheese versus Lovejoy. That is what happened in the case of Cheese versus Lovejoy. Another case is the case of Re-Southerden. Re-Southerden is re and south den. Re-Southerden. So again, the couple were traveling from the UK, from England to the US. The guy made a will and said if he died, everything should go to the wife. Okay, so he went to the US and they came back safely. Okay, now one day while they were just basking around the fire, he took the will and burnt the will. Okay, the question that came about was whether that will was revoked, and the court said no, this guy did not revoke the will. Why? In as far as there was actual destruction, there was no intention. So this person did not intend to destroy the will. So by the fact that they didn't intend to destroy the will, the destruction did not mean, he didn't intend to revoke the will, the destruction did not mean anything. So guys, that must be accompanied. The two things must come together. That is the actual destruction and the intention. So if one is missing, then that will is not revoked. If one is missing, then the will is not revoked. Guys, are we together? Are we together?
Yes, we are.
All right. Now that is Re-Southerden. That is the case of Re-Southerden. Now we also have the case of Re-Jones. You guys know what the case of Re-Jones says. In that specific case, what happened was that this old lady made a will and gifted the nieces, and then the nieces stopped visiting. Okay, the nieces stopped visiting. So when he got sick, almost around to die, he took the will and tore the signature page. He tore the signature page of the will, and then he sent the nurse to go and call his lawyer so that the lawyer can make another will. Now, the court held that that will was actually revoked because, number one, there was destruction of the signature page, and then lastly, there was the intention to make another will. So the will was successfully revoked. Are you together? Okay, perfect. Now, that is the question of revocation by the voluntary revocation. Now let us go to the involuntary revocation. This is revocation just by operation of law or something that happened. Okay. The first one is the question of marriage. So when you get married, then it is deemed that any will that you made before the date that you get married, that will shall be revoked. So if you make a will today and you get married next week, then the will that you made today shall be deemed to have been revoked. that will shall be deemed to have been revoked. Why is the law assuming that the will shall be revoked? Okay, because when somebody gets married, there's an expectation that they might, not all the time, there's an expectation that they might get children, and they might also, because now they have a wife, they can get children as well. So this person is going to have new dependents. Okay, so unless the will that he made was providing for this new dependents, the law specifically assumes that that will is invalid. Why? Because we expect this person to provide something for the dependents because now he's married. Okay, so if you make a will when you're single, when you finally get married, the law assumes that you need to change. You need to change your will because now you have new dependents. So that is why the will is deemed to have been revoked. But remember that unless you specify the name of the person you are going to marry in the will. So if the person that you are going to marry is the one indicated in, or the person that you married is the one indicated in the will, then at that instance, the court will not revoke that will. The will shall not be considered to have been revoked. So marriage automatically revokes a will. Marriage automatically revokes a will, and I've tried to explain the reason why. The reason why is when you get married, there's an expectation that now that you have a wife, not only you have a wife, but also you might be having kids, and therefore you might consider leaving something for them when you die. So that is why your will is effectively revoked. Okay. Now on the other side, divorce does not. Okay, when you get divorced, that does not revoke a will. Divorce does not revoke a will, but marriage revokes a will. That is revocation by marriage. The other one, which is also an involuntary type of revocation, is loss. Okay, loss, where the will is lost. So if the will is lost, then we shall assume that the testator actually revoked the will before he died. So if that will is lost and we can't find it, we shall assume that the testator went with it to his grave. Okay. So if the will is cannot be found, it is lost, then we can assume, or we shall assume, that the testator actually left with the will, and therefore there is no actual will. It was revoked before he died. So that is the assumption when it comes to the question of revocation by loss. The other way of involuntary revocation is still the making of another will or codicil. When you make another will or codicil, there are two instances there. One, it can be a voluntary revocation. It can be a voluntary revocation whereby you specifically say in that will that all my wills, all my former wills hereby or are hereby revoked. You can make a will and say that all your wills are revoked. Are you together? You can make a will and say that all your wills are revoked. That is the first one. So when you do that, that is a voluntary revocation. You are revoking the will yourself. You are revoking the will yourself. Now, the second instance is you will make another will, but that other will not mention anything about other wills. Okay? You will make another will, but that other will not make any mention about other wills. Are we together? So when that happens, then all those other wills are also revoked. So for instance, if you make a will today, giving everything to your son, and then you make a will tomorrow, giving everything to your mom, then the second will or the later will is the one that is going to be upheld. And therefore it is deemed that the will that comes later in time or comes last will be revoking the earlier will. But again, the rule there is very simple, that those two wills should be inconsistent with each other. The two wills should be inconsistent with each other. Guys, I don't know whether we are understanding that point. Now, you can have 10 wills, guys. You can have 10 wills. If you want to have 10 wills, you can have 10 wills. They will all be valid. Okay? You can have 10 wills and they will all be they will all be valid. Now, at what instance will those wills not stand together? If they are inconsistent with each other. For instance, if you have 10 pieces of land, you can make 10 pieces, 10 wills giving each to every person. Okay? But if you have one land, and this land you give it to two different people in the same, in different wills, then the latest will shall be carrying the day. Are we together? So if the second will is contradicting what was in the first will, then the second will shall be deemed to be the latest version, and therefore it is what will stand. So the two wills must be inconsistent with each other. They must be contradicting each other for us to deem that they have actually, that the first one has been revoked. Are we together? So the two wills must be different. So must be providing for the same thing. So I want you to understand that point. And if you don't understand it, put up your hand. If you don't understand that the point that I've just made in terms of making another will, how that will indirectly revoke a will, please put up your hand. All right, nobody has their hand up, so it means everybody has understood. So when you make another will, there are two things you can do. You can indicate that all my previous wills are hereby revoked, or you can just leave it and give your provisions to your dependents, and then if it is found, if we find out that those two wills are inconsistent with each other, they are contradicting each other, then the latest will shall be upheld. The latest will shall be deemed to be the valid will. Then it shall revoke the earlier will. That is what revocation of wills in terms of making another will is all about. All right, any question up to there? Any question up to there? That is revocation of wills. Revocation of wills, that is exactly revocation of wills. So we have discussed the question of making another will or codicil. We have discussed the question to do with destruction. We have discussed the question to do with marriage, loss, and also the further explanation on making another will or codicil. Any question on revocation? No question. All right, so if there's no question on revocation, then let me just mention that revocation can only be done by the testator. Revocation of wills can only be done by the testator. It is only the testator that can revoke a will. Okay? If you are not the testator, you can't revoke a will. Even the court cannot revoke a will. Okay? The court cannot revoke a will. Are you together? So it is only the testator that can revoke a will. I want to understand that very well. Because once somebody has made a will, then that person is bound by that will, and nobody can touch that will. Nobody can come and touch that specific will. So wills are revoked by the testator. After the testator has died, then the only thing you can do is you can construct the will, construction of wills, and you do that specifically to try and ascertain, okay? You do that to try and ascertain what the testator might have meant in the will, okay? That is why we need the construction of wills, which is just interpretation of wills. Are we together? Now, that is all about revocation of wills. So please have that at the back of your mind. You will be told that somebody did this, and did that. Or you'll be given an instance of two wills in an exam, two wills existing together. You'll be given that instance, and then you'll be told now to advise the status of this will. So you need to understand whether it was revoked or it wasn't revoked. That is how revocation is handled. That is how revocation is handled. All right, so after that, I want us to go and talk about the question to do with, the question to do with construction of wheels. Construction of wheels, guys. Construction of wheels. Now, what is construction? When something is being constructed, we are simply, okay, we are simply saying that you are interpreting. So construction of wheels is all about interpretation of wheels. You interpret the wheel, okay? You interpret the wheel. So wheels are interpreted. Why are the wheels interpreted? I've just explained right now that once the deceased person has died, there's nothing you can change in that will. Once the deceased person has died, there's nothing you can change in that will. And that is why wills are constructed should there be need to construct the will. Okay? Should there be need to construct the will, then you will construct the will. So when do you construct the will? Number one, maybe to identify what the testator meant by something, to identify what property is there, to identify which the beneficiary the property was meant for. Okay, so that is the question of trying to construct a will. So you need to understand the will. Okay, so construct and understand what this person might have meant, and this only applies in the instance where the wishes of the testator are not really clear. So if the wishes of the testator are not very, very clear, then you will proceed and construct the will. Now, there are two things that people confuse. The first one is a will and a grant. Okay, a will and a grant. Now, wills, guys, wills, I want to understand, wills are constructed, or wills are interpreted, interpretation of wills. Okay, wills are interpreted, interpretation of wills. Now, grants are rectified. Grants are rectified. So let me give you an example. Okay, so we find that the will that was left by Mr. Abdi indicates that the property in question is LR number 134/1 should go to his son. That is what the will is saying. LR, I, Abdi Nur, I hereby bequeath my land, LR number 134/1, maybe in Kajiado to my son. Okay, and then it is later realized that that land is not 134/1, it is actually 131/4. So if we realize that it is 131/4, not 134/1, then that is a mistake in the description of the property. Now we can't rectify the will. We don't have the power to rectify the will. Why? Because the will was made by a person who already died. So we can't rectify his will in his death. So we can only try and interpret and apply the rules of interpretation of will. For instance, the golden rule, the armchair rule. We will insert those rules and try and see what the testator could have meant. Did the testator mean 131/4 or 134/1? So in that, we just try and assume what could this person have meant. Now, for a grant, if the grant is issued, because remember when the grant is issued, the grant comes and indicates who is supposed to get what. Okay, that is usually indicated in the grant. It is indicated in the grant. Are you together? Now, if we realize there's a problem in the grant, then we don't interpret the grant. We go and rectify the grant. So grant is like a court order. If a court order has a problem, you go and review the court. You go and review the court order. So that is rectification of grants. Grants are rectified, but wills are interpreted. Any question? Oh, yes. So let's start with, oh, there's no question. Okay, so that is that. So that is your assignment of the day. And I want this one, I want somebody to give us a presentation next week. 2 people to give us a presentation next week in terms of the rules of interpretation of wills. So I want volunteers. Somebody wants to volunteer to give us a presentation on the rules of interpretation of wills. Just at 2 minutes, at 2 minutes or at 3 minutes. That is the assignment. Who wants to try that assignment in the next class? Oh my goodness, nobody. Oh my goodness. No one really? Yes, Ndanu. Is it Gloria?
Yes.
All right. So you will give us the presentation in the next class, and of course, it will be a free class for you. So you just, it is that 2 minutes thing, not so much of time, just 2 minutes or 1 minute, so that we can see what you have. But also remember that everybody here, that is the assignment. Go and read on interpretation of wills. Okay, Joan. Joan, your hand is up.
Okay, can you hear me?
Yes, I can.
Okay, would you kindly repeat on that point of grants, please?
What point exactly? First, tell me what you've understood, and then I know what you have not understood.
You are talking about how a will cannot be rectified once a testator has died. There is no rectification that can be done to a will. And there is a point that you have said about grants. I don't know something. I've not heard well because I was having network issues.
Stop lying to network issues. Guys, you keep saying that you have network. Don't lie to networks. I don't like liars. Just say, I've not understood this point. Could you please explain it again? You don't have to come and say, oh, I was having network issues. Don't lie, even when network is okay. Okay? Just say, I'm not getting this point. Please explain it. Network issues, Nini. Don't lie. I don't like liars. I don't like lying. Okay? So, like I've said, okay, like I've said, we have grants and we have wills. I was just giving a point. Wills are interpreted. We can't go into a will and start writing anything or changing anything in a will. We can't. So wills are only interpreted to find out what this deceased person might have meant. On the other side, we have grants. A grant is a court order. So when a grant is made, that grant comes indicating what is supposed to be given to who and who and who. Now that grant sometime might have a problem. For instance, the grant might say that it is 134/1 when it is 131/4. So any problem with the grant, that problem could be description of the property, description of the deceased person, description of the beneficiaries. Any problem with the grant, we go and rectify. We go to court and tell the court that no, this grant is wrong on this, please correct it. And then they will correct it, whether it is a grammatical error or just any other error. Okay, and then if it is a will, we have to interpret it. We just interpret it. We can't rectify. Rectification simply means you go and change. We can't change a will. Once it is written and the person has died, we can't change it. So any amendment to a will can only be done by the deceased person. Are we together? So that is exactly what you're saying in terms of rectification and interpretation. Are we together? Joanne?
Yes, thank you.
Very well. Okay, now that's being clear, I want us to go and talk about the question to do with gifts. Gifts in a will. Gifts in a will. How do we handle gifts in a will? Gifts in a will. What are these things we're calling gifts in a will? But first, questions. Anyone with a question? You guys have not spoken much. Ama you guys are having network problems? I don't think so. Anybody with a question? I know I've moved very fast. That's why I'm coming back again. So I'm giving you guys an opportunity to ask questions. Whoever was having a network problem, please. If you didn't hear anything, ask. I can pick some of you here and I will ask them the same question I've said, and they will not answer me. Okay? You think I'm lying? Should I start asking? Any question so that we can go and talk about gifts in a will, and then I can maybe show you a structure of a will.
Always
What is that language, my friend? Is that language legal? My friend Mohammed Hakmet, is that a legal language? All right, any question? Okay, so let's start with somebody called Kathwa Alex. Are you there? Kathwa Alex.
Yes, Mwalimu. Yes,
What is
Mwalimu,
the
I'm present.
Yes, what is the difference between construction and rectification?
Construction of wills refers to wills, while rectification refers to grants.
What is the difference?
The difference is that wills are constructed while grants are rectified.
Use an example so that we understand.
Like a will is constructed to mean or to identify what the testator wanted or the understanding of the will. Well, let's say in a grant, if it has some errors, it is taken, application is made to the court so that it can be rectified in the way which is suits the beneficiaries.
Perfect, amazing. That is a very wholesome explanation of that. So guys, that is what rectification and construction are. Now let us go to gifts in a will. We will end our discussion with wills today. I mean, the first part of probate is tested succession, which will end today, and then we start intestacy. Now, gifts in a will. What are the different categories of gifts in a will, and then what are the different doctrines of gifts? So the first one is a specific gift. A specific gift. Okay. A specific gift. That is the first one. A specific gift. Okay. Now, give me a minute. All right. Now, a specific gift is a specific gift given to someone specific. So if I say in my will that my car, okay, Toyota, this and this, registration number this, will go to my daughter, Susan. That is a specific gift given to a specific beneficiary. A specific gift given to a specific beneficiary. So you identify the specific gift and then to a specific beneficiary. The next one is a class gift. A class gift is a gift that is given to a class of people. Class gift is a gift that is given to a class of people. Okay. For instance, if I say my car, Toyota, KBX number 212X will go to my sons. My sons. Okay? Then that is a class gift. Or I say that this specific asset will go to my wives. Then my wives are the class. It will go to my daughters. My daughters are the, so any identifiable class of people. Okay, it will go to my grandchildren. So it can only go to the grandchildren. Okay, so a class gift is a gift that is given to a specific class of beneficiaries, a specific class of beneficiaries. So it's not one person. Okay, it's not one person, but it could be one person. Okay, for instance, this car will go to my sons, and then by the time you're dying, you only have one son. Okay, that is still your sons. So it is a gift that is given to a class of people. And then we have the residuary gift. What is a residuary gift? Okay, what is a residuary gift? Now this is a gift that is made from the residue. Okay, from the residue of the estate. So what is the residue of the estate? You guys know the filtrates and the residues in chemistry. Okay. Now, what is a residue of the estate? So if the gift is made in this manner, okay, you will be saying 10% of my estate, my son, 30% my wife, 50% my daughters. And then you say that 10% of what remains, okay, 10% of what remains shall be given to my grandmother. Then that is a residuary gift. It is made from the residue. Residue is what remains. Okay. So when somebody says that 10% of what remains shall go to my sons, okay, if you say that 10% of what remains shall go to my son, then that is a residuary gift. It is made from the residue. Residue. Right together. It is made from the residue. That is what we are saying. So a residuary gift is a gift that is made from the residue. It is made from the residue. So you are saying 10% of what remains I will give to the church. 10% of what remains you give to the school. 10% of what remains you give to my friend. So that is a residuary gift. It is part of what remains. Okay. So those are the three main types of gifts that we have. The residuary gift, specific gift, and the class gift. Okay. Now let us go into the doctrines surrounding gifting. The doctrines surrounding gifts. The doctrines that will surround gifts. Are we together? So what are these doctrines? The first one is the doctrine of election. Somebody tell us, what do you understand by the doctrine of election? Mute your microphone. What do you understand by the doctrine of sorry. What do you understand by the doctrine of election? Give me an answer. Bishar Abdi Ibrahim. What is the answer? And why don't you have an English name? Abdi Ibrahim. Are you in this class? Okay. Abdi Ibrahim is not here. I can see him there, just sitting. All right. Any person wants to explain to us what the doctrine of election means? Now, guys, these doctrines are supposed to be applied. You'll not be told specifically to discuss the doctrine of election. You can be, but most of the time you will find it in the question. You will find it in the question, okay, without the examiner mentioning it. So from there, you need to actually say that that is an instance of election. That is the doctrine of election. So what is the doctrine of election? Yes, John. Who are John?
Okay, let me give it a try. There may be an instance whereby a testator may have bequeathed a certain property or a certain gift to a beneficiary, and then during their lifetime, the same property or the same gift they bequeath, they give the same beneficiary in form of a gift. So the beneficiary will have to choose whether they will elect whether to accept the gift as it has been, as they have been bequeathed in the will, or they are going to accept the gift that was given during the lifetime of the testator. Maybe, for example, through a donation motis causa. I stand guided. Thank you.
All right, that is an amazing response. That's an amazing response. So exactly what it is just what she has already explained. Okay, so when it comes to the question of election, this is where, okay, this is where, and this needs to be very clear, that the deceased person bequeathed a beneficiary a gift in the will. At the same time, the deceased person bequeathed another beneficiary something that belongs to the first beneficiary. Okay, so assuming that John and myself are siblings, so our father only has, let's say, a piece of land. Okay, now I have a car and my father has a piece of land. Now, if my father makes a will and bequeaths me the piece of land and bequeaths my car to John, then I am the one that is going to be put to election to elect, number one, whether to go by the will. Somebody's microphone is on. It is, I'm going to choose or elect whether to go by the will, that is to forgo my car and have the land, or to have the land as well as take my car back from John. That is the question. Mute your microphone, please. Are we together? Okay. So I have said somebody's having the microphone on. Kindly mute it. Okay, mute your microphone. So when I say you mute your microphone, just look at your screen. It's very simple. It's not complicated. It's not rocket science. If you hear me saying that somebody is having their microphone on, just look at your screen and see, is it me? If it is you, you unmute, you mute. I don't want to go looking for you so that I can tell you to mute. Just look at the screen and see kama ni wewe umeunmute and then uzime tena. Okay. All right. So we are talking about the question of election, and I've said the person that is going to be put at election is me, either to decide that I'm going with the will, or I am going to have the will as well, and also take my property back. Okay. So that is what you're calling the doctrine of election. Yes, somebody is having a question. Somebody is having a question. Ask that question as we move. Yes, ask. Gloria. We can't hear you. Can you speak up? We can't hear you, Gloria. Can you speak up? Okay. Looks like we can't find you. You are speaking, but we can't hear. Okay. I don't know what's wrong with your microphone. Something is wrong. So you might want to leave and come back again so that you can be able to hear us. Or we can be able to hear you. We can't hear you now. All right. So any
Excuse
question
me,
on?
sir.
Yes, can you hear us now?
Actually, it's not her, it's Evelyn.
Yes, proceed. Yes, proceed, Evelyn. Yes, proceed.
So for me, I want to find out what happens in an instance whereby the first person who'd been gifted through the will and they are put on election, they happen to choose to remain to go as the will, the way the will provides, and they take their property back. Now, what happens to the other beneficiary who had been bequeathed the gift that belonged to the first person?
They need to be given something. So normally, the law provides that you have to give them something. You have to. So if I take it from my sister, I have to give my sister something small as compensation. Okay, as compensation.
Okay.
So you have to give them something. Okay, from your own pockets. Why? Because remember, if you don't, they will go to court and apply for reasonable provision, and whatever you are given, you will divide with. I mean, you will have it equally. Okay, you will have it equally. So the best way is normally you have to give them something in exchange as compensation for whatever they were given that you're now taking back. Okay, so yes,
Thank
that
you.
is the rule when it comes to that. So I'm going to explain the question of I'm going to explain the question to do with election once again, and I'm going to use an example, or I'm going to say like this: an election is whereby the deceased person bequeaths beneficiary number one piece of land or any gift. At the same time, he bequeaths beneficiary number two something that belongs to the first beneficiary. So in that instance, the first beneficiary will be put to election to elect whether they want, okay, to go according to the wishes of the deceased person, and that means they will only take what was given to them, and then they will forego what was theirs that was given to the second beneficiary, or that they are going to take what is given to them in the will. At the same time, they are going to be claiming back their property from the second beneficiary. Now, if they do that, they'll have to give the second beneficiary something. They have to give the second beneficiary something. Okay, because this person is a dependent as well. Is a dependent as well. So if you don't give them something, they will just apply to court to give them orders of compensation. That they need to be given something, orders of reasonable allocation, and then you have to divide whatever you have with them. So instead of that, you can always choose to just compensate them with something as an appreciation, really, or as a compensation for what you've taken from them that didn't belong to the deceased person. So that is the question of the doctrine of election. Any other question? All right. Now, the doctrine of election has been confused with the doctrine of disclaimer and the doctrine of variation. Are we together? The doctrine of variation and the doctrine of disclaimer. So what are these doctrines? What are these doctrines of disclaimer and the doctrine of variation? Okay. Now this is what everybody confuses as election. Okay. This is what everybody confuses as election. Okay. Now, if the deceased person or if the testator gives you something in the will and you don't want it, you don't want to take it, then you can fall under disclaimer or you can fall under variation. Okay? So the fact that you're given something that you don't need or you reject, when you reject something that was given to you in the will, then that in itself becomes the question to do with variation or disclaimer. So when is it variation and when is it disclaimer? Okay. Now, when it is disclaimer, there are 3 rules that apply. When it is disclaimer, there are 3 rules that will apply. The first rule, okay, is that when you are disclaiming, when you're rejecting what was given to you in the will, you have to reject before you accept. What I'm saying is this: you cannot reject after you've accepted. So once you accept it, it is yours. You can't reject it. Okay? So that is the first rule. You can't reject after you've accepted. That is the first one. The second rule, when it comes to disclaimer, is that you cannot reject part of it. You either reject all of it or take all of it. Okay? Reject all of it or take all of it. And then the last rule of disclaimer is that once you reject it, you cannot decide or dictate who is supposed to take it. So once you reject it, then the administrator or the executor will, the executor, or even the administrator, yes, the executor or the administrator will decide how to deal with the property, and the property will go back to the residue of the estate. Those are the 3 rules when it comes to disclaimer. So the first one is you cannot reject after you've accepted. Number 2, you cannot reject in part. You cannot say that this was 10 acres, give me 5. I only want 5. No, you can take it all or you leave it all. And then lastly, once you reject it, you cannot say where it's supposed to go. You can't say that now I don't want it, give it to my sister. No, you don't have the power to decide when you are disclaiming. Okay, that is disclaimer. Now, the second one is variation. Now, for variation, it is the opposite of what we've said in disclaimer. So under variation, you are also refusing to take what was given to you. But number 1, you can refuse, you can take it back even after taking it. Once you've accepted it, you can still take it back. Okay, you can vary, if there's a word, after you've accepted. Number 2, when it comes to variation, you can take half or you can reject part and take the other part. You can say 5, this is 10 acres, I only want 5, and then take away the 5. So that is possible when it comes to variation. And then the next one, or the last rule, is that when it comes to variation, you have the opportunity to decide who is supposed to get it if you don't get it. Okay? For instance, if it is 10 acres, you can say, fine, I don't want the 10 acres. I only want 5. The remaining 5, please give to my sister. So that will go to your sister. So for variation, you have the right or you have the opportunity to decide who is supposed to get it in case you don't get it. Okay, I mean in case you reject it. So you can decide who benefits from it. That is the question of disclaimer and variation. Now, in summary, disclaimer and variation as doctrines, they relate to the beneficiary rejecting what was given to them in the will. Are we together? And we have discussed the difference between variation and disclaimer. For disclaimer, you cannot reject after you've accepted. For variation, you can reject even after accepting. For disclaimer, you cannot reject the part and accept the part. In this variation, you can reject part and also take the other part. And then lastly, for variation, for disclaimer, you can't decide where the property or who is supposed to be given the property once you reject it. But for variation, you can decide who takes the property once you reject it. That is a question when it comes to the doctrine of disclaimer and the doctrine of variation. Questions? Gloria? Gloria, we can't hear you. I told you to leave and come back. You don't listen. Leave the class and then join again. We can't hear you until you leave and come back. So Liv, I will add you back and then you can speak. All right. Gloria, can you hear us now?
Hello, you can hear me.
You see? Yes, I told you. Yes, I can hear you now.
So in short, you're saying the variation is the opposite of disclaimer. Whatever is stated in the doctrine of disclaimer is the opposite of what is stated in variation.
Yes.
Okay.
But all of them relates to what is the circumstance? What is the circumstance that will lead to both variation and disclaimer? The circumstance is very clear, and that circumstance is the beneficiary is rejecting what was given to them in the will. Now, how will you know it is variation or disclaimer? Okay, the first one you look at, have they accepted it? Are they rejecting half? Or are they deciding who is supposed to take it? Okay, after they reject it. That is what you're calling variation and disclaimer. All right, Rachel. Morning.
Yes, hello. My question was just to see if I understand this correctly. The thing, the property that the donee is gifting apart is in the doctrine of election, the donee is giving away property that does not belong to him, belongs only to that beneficiary independently. Is that what's happening, or is it also property still that I have a bit of confusion there? I'm trying to understand.
Just give me a second. Give me a second, please. Yes. Sorry, guys. Let's start. Rachel. What is the question? Sorry, I was handling something, Maj.
Yes, my question was in the doctrine of election, this property whatever it is that the testator is giving away that belongs to maybe the first beneficiary, is it his individual, is it the beneficiary's individually owned property away from the testator, or is it something that forms part of what the testator was gifting the beneficiary in his will, or is he giving away property that does not belong to him and solely belongs to the first beneficiary?
Yes, it doesn't belong to him. It doesn't belong to him at all. You get the point?
Oh, so it was like mistake, like he made.
Yes.
Okay.
Kind of.
Okay.
Kind of. All right. Yes, Wakiaga.
Yes, good evening, Malim.
Yes, sir.
Who decides whether an occurrence is a variation or a disclaimer?
It is the wishes of the what do we call it? The wishes of the beneficiary. Okay. So if the beneficiary is intending to take part half, okay, then that is variation. Okay. If they are intending to to decide who it is going to, then that is variation. So really, so the judgment on variation or disclaimer is after the fact. After something has happened, that is when you can decide and say this is variation. So for instance, if the beneficiary goes straight to the personal representative and says that, hey, I don't want this property. Okay, I don't want this property at all. Okay, and then they'll be given the options, and the options are, listen, you don't want the property. These are the two options that you have, because remember they have to swear a statutory declaration. They have to swear what you call a statutory declaration, either disclaiming or varying. So you will tell them that, hey, when it comes to variation, these are the options. When it comes to disclaimer, these are the options. So you pick one. Okay, so they can either decide and say, Mimi, I don't want it. I don't want to take half. I don't want to know who takes it later. That is disclaimer. So they are going to disclaim by way of a statutory declaration or affidavit to the testator. So sorry, to the what do we call it? To the
administrator.
Personal, yes, personal representative, or they are going to do a variation to the personal representative. Tuko sawa?
Thank you.
All right, so that is the doctrine of disclaimer and variation. Let us go to the presumption, the doctrine of presumption of satisfaction, the doctrine of presumption of satisfaction. What is this saying? Now, this relates to debtors. It relates to creditors, actually, creditors. Okay, this relates to creditors. In what sense does it relate to creditors? In what sense is it relating to creditors? Okay, the first one, remember that if there is anything that is owed to a creditor from the estate, assuming that the testator owed one of the creditors something, and then the testator made a gift in the will saying that 1 million from my bank account shall go to Baji Barako. Then the law assumes that what has been given to a creditor is given to him as a full settlement of, or as part settlement of what was owed to him. So this creditor cannot come and say that, oh, hii amenipea tu, bado akona deni yangu. No. When you are given something by the deceased person who owed you money as a creditor, then the law assumes that the only reason why he's giving you that is because he wanted to settle your debt. So what was given to you will offset the debt that he was having. Are we together? Sidhani kama mko sawa. Unanisikiza?
Hatuko sawa.
Okay. I am going to repeat. And I'm going to say this. Who was saying I repeat? I need to use your name. Who was saying
Me.
repeat? Who is
Rachel
me?
Omole.
Rachel. So we are going to say this. So Rachel, assume that I die. I know I will not die, but assume that I die. Okay. And by the time I was dying, I owed you 1 million shillings. So I died with your debt. So in my will, if I write that 1 million give to Rachel Omondi, then the law assumes that what I've given you in the will is to satisfy the debt that I owed you. And therefore, you as Rachel, you cannot take the 1 million and then come again and claim another 1 million as debt. That is what we're calling the principle of the doctrine of presumption of satisfaction, that what you are given is deemed or is presumed to be satisfying an existing debt. Because our Rachel,
Yes.
any question on that? Presumption of satisfaction. Kama hujalewa mkono. All right, that is okay. Now let us talk about another principle, which is the principle of ademption. The principle of ademption. Ademption is very, like I guess I've said, these principles, you'll not find them openly in a question, but you'll see the fact pattern that relates to these principles. More so when it comes to wills, they only apply to wills or gifts in a will. Okay, what is the doctrine of ademption? Now, ademption relates to property. Okay, ademption relates to property, and then lapse relates to beneficiaries. So what is ademption? Ademption is where the property that was given, the gift that was given, is no longer existing at the time of the death of the deceased person. So if you are given a car, by the time the deceased person dies and that car is not existing, it has been sold off, it has gotten itself in an accident, or it was stolen, then that gift is deemed to have addeemed. That is ademption. So the gift is addeeming on the basis, okay, on the basis that it is not existing at the time of the death of the deceased person. Okay, so that is what you're calling ademption. So what is the rule in terms of ademption? So we are simply saying the property is not existing at the time the deceased person dies. Okay, now this relates to which feature of the will? We talk about features of the will. This specific ademption will relate to what feature of the will? Okay, both ademption and lapse. Okay, let me explain lapse and then you will tell me. So that is ademption. So what happens in ademption? The property that was a subject, the property that was subject, okay, the property that was subject to this specific will is no longer existing. It has been sold, it has been done, everything, it is not existing anymore. By the time the deceased person dies, that property is not there. So the property or the gift will be deemed to, will be considered to have deemed. Okay. Now, what if the property was sold? Now, if the property was sold, if there's a contract to sell the property will only deem if by the time the deceased person was dying, the contract price was already paid, then it will deem. But if the contract price is yet to be paid by the time the deceased person is dying, then the beneficiary who was given the property is entitled to receive the contract price. Let me give an example. Again, if your father gives you the piece of land in Karen, okay, by the time he's dying, he has already sold the piece of land. There are two things. He has sold the piece of land, but has he been paid? So the first instance is he has been paid and he has eaten the money. Number two, he has not been paid or there's a pending payment. So if he has eaten the money, then that is a done deal. Okay, that gift has deemed. It is no longer there. There's a contract to sell it, he sold it and he squandered the money. Okay. The second instance is he sold the land, but by the time he was dying, the contract price was not been had not been paid. Now, in that instance, you will be entitled to receive the money. So it will be deemed like he sold it for you. So you'll just get the money because the land was given to you and it was sold. So you'll receive the benefits of the sale. So that is what you're saying. So always get that aspect of it. Okay, always get that aspect of that is the question of redemption. So the property redeems. General rule is if the property is not existing at the time of the death of the deceased person, then that specific property is redeemed. All right, then the doctrine of lapse. Okay, the doctrine of lapse. So in terms of lapse, this is very simple also as well, is the beneficiary is not existing. Okay, the beneficiary is not existing at the time of the death of the deceased person. Redemption, the property is not existing. Okay, lapse, the beneficiary is not existing. Are we together? So let us give an example. So if you are given something by your father, okay, you're given something by your father, let's say a piece of land as well, okay, but you die before your father. When you die before your father, that gift will lapse, okay, it will lapse. The gift will lapse if you die before your father, okay, but there are exceptions to that rule of lapse. What are the exceptions to the rules of lapse? Now, before we get to the exception, my question still comes. What are some of them? Okay, what are some of the instances? What are some of the instances? No, let me not ask it that way. Maybe that's another question. Now, in terms of lapse and redemption, this relates to which feature of the will? We discussed features of a will. What feature of the will speaks to lapse and redemption? Mikono juu. First hand up. First hand up. Tianga Jennifer.
It is intended to take effect upon the passing of the testator.
Yes, pre-class kwako. So a will is always intended to take effect after death. That is one feature of the will, that the will is intended to take effect after death. And that is why if you die before the testator, there's no gift for you. If you die before your father, then you died when there was no will. Okay? The rule is very simple. Why is it a deeming? Why is it a deeming? It's a deeming because by the time you're dying before your father, there is no will. Yes, there's a will that was written, but that will is only supposed to take effect after he has died. So if you die before your dad, the gift will not come to you because it has lapsed. But anyway, even you shall have expired. So there is nothing to talk about. There are exceptions to the rules of lapse. Okay, there's an exception when you dying before your father will not lapse the gift. The first one is what you're calling a class gift. Okay, 2 hands are up. Are there questions? The first one is a class gift. So if your father made a class gift, that gift will not lapse if one member of the class dies. What am I saying? If the father said in the will that this car shall go to my sons, and one son dies, the car will remain with the remaining sons. So if it is a class gift and one member of the class has died, then that gift will not lapse unless they have died all of them. Okay, that is a class gift made to a class of people. And then number 2 is a joint gift. So if your father says that this car is given to my daughter and my son jointly, then if one person one person dies, one beneficiary dies, that is your father, sorry, that is the son or the daughter, then the surviving one will have the property. That is a joint gift. Okay, the next one is gifts that are made in satisfaction of a statutory obligation. Gifts that are made in satisfaction of the statutory obligation. Are we together? So number 1, a debt. If you make a will and give something to the debtor and say 1 million shall go to Michael, who is my who is my creditor that I owe money. If Michael dies before you, you can't say that, oh, now that he has died, ideni sitalipa. No, you have to pay it. That gift cannot lapse because it was made in satisfaction of a legal or a statutory obligation. Okay? The other one is child maintenance. If you're paying child maintenance or any wife-related payments, those are statutory obligations. You have to keep paying them. Okay? You have to pay them. So you cannot say that this person has died, now this gift will lapse. So those are the instances where those are the exceptions to the rule of lapse. So the gift will not lapse, guys. The gift will not lapse if there is evidence, that it is a class gift, it was a joint gift, or is a gift that was made in satisfaction of moral or statutory obligations. Because Zawa, I hope to Konzawa. Those are the doctrines that we have. Those are the doctrines that we have in gifts or in wills. Any question before we get to the provision for dependence? Maswali? Yes, Tua Joan, we start with you.
Okay, kindly elaborate more on the gift made in satisfaction of a statutory obligation. I've missed that one.
What have you heard?
I've just heard about child maintenance.
But I've
That
given
is
examples.
one of the statutory obligations.
I've given examples before that. You not heard anything?
I might have missed.
What do you mean you might have missed? Do you know the word might? What the word might means? Mm-hmm.
I have missed. Maybe my mind was wandering somewhere else.
Bring your mind back to this class. Huyo mtu atakudanganya tu, atakuacha. Bring your mind here. So, let us talk about the statutory obligation or gifts that are made in statutory obligation. So tumesema Tua that when it comes to these gifts, when it comes to gifts that are made in satisfaction of statutory obligations, they include things like when you're making a gift to satisfy your debt. Okay, so if I'm a creditor, you owe me money and you make a gift to me and I die before you, you can't now go and say that, oh, this person has died, so I don't owe him anymore. You owe the estate, you will still pay because it was a statutory obligation. Child maintenance, if you're paying child maintenance, okay, if you're paying child maintenance, then if that child maintenance was being paid to the wife, for instance, if it was being paid to your former wife, let's say your ex-wife, you used to give your ex-wife 20,000 every month for child maintenance. If your ex-wife dies, you will still keep paying, even though the beneficiary has died. You still keep paying that child maintenance. You will find a new person to come and collect money from you. Okay, so child maintenance is a statutory obligation, a legal obligation. So a debt, child maintenance, those are statutory obligations, and you have to keep paying. I don't know kama tunaelewana.
Yes.
Okay, perfecto. Swali lingine? Tianga, Jennifer?
There's a response you gave to Rachel when she asked about the doctrine of election. You see that the gift that is given, that belongs to the first beneficiary, given by the testator, is based on a mistake. That threw me off a bit because I just thought the testator just elected to bequeath that gift to the second beneficiary without consulting the first beneficiary. I don't know. I'm a bit confused with that.
It is not. Remember, the person that elects is not the testator, but it could be as a result of a mistake, or it could be your father just being your father. Your father just exercising discretion and saying that, oh, wewe uko na gari, siwezi kupea shamba tena, wacha nipee hii gari yako kwa your sister. Or it could be an honest mistake. Your father could think that he actually owns that vehicle, but he doesn't. Okay? Or just a clear discretion. So it could be a mistake or it could be a clear intention. Okay? But what matters is the fact that your father gave something that doesn't belong to him to your sister. So do you leave it with your sister or do you go and take it back? That is election. Okay?
Okay. Okay, thank you.
All right, Omwenga.
Thank you. Me, I was asking a question
Mm-hmm.
on exceptions of the doctrine of lapse, where, for instance, someone was bequeathed, I don't know how to put it. You gift, the deceased gifted a child, or the testator, sorry, gifted a child of the deceased or something like that. There's an
The testator,
exception.
the testator gifted a child of the deceased. What are you saying, my friend?
And
Hebu jaribu kusema kwa Kiswahili.
I think it's under paragraph 2(1) of the, maybe I look at it. There's an exception, I can't remember well, to the rule of lapse.
Oh, sorry.
Where a
Sorry,
child,
thank you. Thank you very much. I've just remembered it offhand now. Thank you. So that is where the beneficiary had a child, okay, left behind an issue. So if the beneficiary left behind an issue, then that gift will not lapse. Okay, so if you gave me something and I die, it will go to my child. So it will not lapse. So you cannot say that it has lapsed. So it will go to my child. That is the third that is the fourth exception to the rule. I hope that is what you're looking for, Omwenga.
yes, thank you.
Yes, so if you, the beneficiary died but left behind an issue, that is the child, then the property shall go to the child. Okay, whatever was given to the dead beneficiary will go to the child. Kefa Omoi.
Yeah, thank you, Mwalimu. My question relates to the doctrine of satisfaction. And you have explained that in the will, the testator bequeaths a person that he owes. Then naturally that would be taken to satisfy that debt or part thereof. Now, suppose the testator is categorical that this gift is independent of the debt. Will it still be interpreted within the doctrine of satisfaction?
Why would we interpret it if the will is clear? You say that the person was categorical and say this is not satisfaction of the debt. Why would we need to? We will not need to even try and interpret anything, because remember, what is the rule saying? Presumption of satisfaction. So we don't even know. We're just presuming. But if the testator clearly says that no, this is not the debt. Okay, this is not the debt. This is, I'm just giving him as my friend. Then that is clear. We don't need to presume any existence of any fact. We just say, fine, you are given something in the will, you give him, and then you pay him his debt as well. So that is clear. So we only presume if it is not clear. Tuko sawa?
Sawa.
All right. Any other question? Okay. Okay, Chumondi. No, not hand up. Sawa. So let us go to section 26. Let us go to section 26, and that is where we will end. Section 26 of the Law of Succession Act is a very interesting bit. Confirm, you can see my screen.
I can see Edward Yator.
Edward Yator, your video is on or something. Your device is kind of different. So try and see if you can mute the video. But let me see if I can project. Provision for dependents. Now, guys, when it comes to the law of succession, the most set question or the biggest thing is usually the provision for dependents. Why? Because it is this part where everybody will be complaining. Everybody will be saying, oh, I was given this, or I was left out, or I was not given something sufficient. You know, that is what happens under the provision for dependents. Okay, provision for dependents. That is what you're saying. Okay, so you need to understand how to deal with. Even in questions, you'll find a question where somebody is coming to you and they're claiming that I'm also a beneficiary, I am also a dependent. I want to get something from the will, or I was left out of the will. I was left out. I was not given anything, or what I was given is not enough for me. Okay, that is what brings the question of provision for dependence. So the first thing you have to understand is who is a dependent. Who is a dependent? Now, when you look at section 26, it clearly gives you the procedure in terms of how to provide for dependence. How do you provide for the dependence of the deceased person? How do you provide for the dependence of the deceased person? Or if somebody comes to you and they're saying they are dependents. So 26, where a person dies after the commencement of the act, and so far as the succession of his property is governed by the provisions of this act, then on application by or on behalf of the dependent, the court may, if it is the opinion of that person, or if it is of the opinion that the disposition of the deceased estate are effected by his will or by gift in contemplation of death, or the law relating to intestacy, or the combination of the will, the gift, and the law is not such as to make reasonable provision for that dependent, the court may order that such reasonable provision as the court thinks fit shall be made for that dependent out of the deceased person's net estate. So simply what that specific section is saying, that if the court sees that the disposition or the distribution in the will, okay, the distribution in the will or the gift, okay, or the gift or the law of intestacy is not sufficient, okay, if it is not sufficient, okay, then the court might make an order that beneficiary be given something out of that net estate. Together. So that is what we are saying. So that brings us to the question that where somebody comes to your office and that person is telling you that, hey, we have been left out of the will. We have been left out of the will. We want to inherit something from our father's estate. Then the first thing you need to ask them is, are they dependents? They must be dependents. Okay? They must be dependents. Okay? So the first thing is they must be dependents. After they are dependents, then they will have to make an application to court. And this application is made by a standard form that is under Rule 45 of the Probate and Administration Rules. Rule 45 of the Probate and Administration Rule. That is where you make this application. That is why you make this application. That is application for reasonable allocation for the beneficiaries under Section 26. Okay. Now you first have to know who is the dependent. I will give an example later. Let us go to 29. Now we have talked about 29 in our last class, or our first class. We talked about 29. We talked about the rule on who is a wife, who is a child, and who is generally a beneficiary. Okay, and they're listed all under 29, and that includes wives, former wives, which we say that former wives are judicially separated spouses, or wives, and then we have the children of the deceased person. Now, this category, they don't have to show any maintenance. They do not have to show any maintenance at all. They don't have to show any maintenance at all. Okay? And then, secondly, we have now the second category of beneficiaries or dependents, which now includes the deceased person's parents, sisters, half sisters, half brothers, nephews, and children that were taken in by the deceased person during his lifetime. So this category of dependents, they must show that they are being maintained by the deceased person. They have to show maintenance. Are we together? All right. And then, of course, we say that section 29, we say that section 29 C was amended. 29C was amended so that this person that was being taken care of by the wife, that is a widower, can also inherit as a matter of right. So the widower also has the right to inherit from his wife's estate as a matter of right. Okay, so that is the question to do with dependents. So once you identify that they're dependents, which is the toughest thing, then you come and explain to them that they need to make an application under section 26. Okay, so that is where we first begin. Are you a dependent? And in trying to establish whether they're dependents, you will be looking at various things. Okay, if they're claiming that they're wives, then you look at the category of wives that we discussed. Okay, if they're claiming that they are children, you look at the category of children that we discussed. If they're claiming that they are maybe the parents or whatever, then of course you know that they have to show maintenance. Okay, if they're claiming that they are children that were taken in by the deceased person, then of course also they have to show maintenance. Are you together, guys?
Yes, we are, Mwalimu.
All right, that is fine. So let us go and talk about this specific application and see the dynamics of this application. So I'll give an example. So person X comes to your office and person X is asking you that he has been left out of the will. He has been left out of the will. He has been given nothing. Okay, now he wants to see whether he can get something. Now the first thing you need to ask is, are you a dependent? Guys, remember, there's no right of inheritance. That is what you need to understand. There's no right of inheritance. You can't say that you have a right to inherit your father's estate. No, that right is not there. Your father will give you what he wants to give you. Okay, depending on your behavior. If you're a good kid, your father will give you what he wants to give you. Okay, you cannot say that now I have to inherit by force, by fire. No, go and work and make your own. So there's no right of inheritance. So we can only distribute the estate of the deceased person by you looking at the will. Okay, so what the testator said in the will, even if the testator said all my properties should go to the orphanage, that is what will happen. All my estate will be inherited by the dog. That is what will happen. Okay, but if you have a complaint, then you have to make an application under section 26 and you ask the court for a reasonable or an adequate provision. Tell the court that what you've been given is not sufficient or you've not been given anything, and therefore you are going to ask for a reasonable provision, an adequate provision. Are you guys together? So once that has happened, definitely once that has happened, then the court will consider your application. So the first thing you need to do is first establish, are you a dependent? Yes, I'm a dependent. Number two, you have to make the application. You have to make an application for reasonable allocation. Okay, reasonable provision. That is an application that is brought under Section 26, you apply to be given a reasonable provision. Now, when do you make this application? Okay, Section 30. No application under this part shall be brought after the grant of representation in respect of the state to which the application refers has been confirmed as provided by Section 71 of the Law of Succession Act. So essentially, we are simply saying that there is a timeline. So the first thing you ask this person, are you a dependent? Yes, I'm a dependent. Who are you? I am the wife, the former wife, the child. Okay, well and good. Or who are you? I am the grandmother, the stepson, or whatever. And or I was a child that was taken in by the deceased person. So for you, you have to show maintenance. Give us evidence that this person was maintaining you. Okay? And then once you do that, then the next thing is you are going to ask yourself, has the grant been issued? No. Okay? If the grant has not been issued, then you are going to make an application under Section 26. If the grant has been issued and confirmed, then you cannot make this application. Remember that anything after the confirmation of grant is just revocation. You revoke the grant. Once the grant has been confirmed, you can't bring any other application. You have to revoke it. Okay? So that application must be made anytime before the grant has been confirmed. Are we together? So are you a dependent? Yes. Has the grant been confirmed? No. You make an application under Section 26. Now, let us go to Section 28. Now, once you make that application, then the court will consider certain factors. And this is where the examiner will always ask you, what are some of the factors that the court will consider? Or you as a judge or a magistrate, what are some of the factors you will consider in entertaining the application that has been brought by person XYZ? Okay? Guys, I said in the last class, and I've just said it again right now, there is no right of inheritance. Okay? Huwezi kaa tu kwako na useme eti babangu anajua mimi niko hapa, ataniachia kitu. Utashangaa. Utaenda hiyo matanga, utakuwa unalia mara mbili. Unalia babako, na tena unalia umeachwa na nothing. You've been left with nothing. Okay? So there's no right of inheritance. Okay? If your father doesn't give you anything, you can't sit at home. If you sit at home, the will will be propounded, the grant will be issued, it will be confirmed in the name of the dog. And there's nothing, my friend, that you can do to help that. You get the point? There's nothing that you can do to help that. So what you can do is you go to court and you make an application. You have to make an application, and once you make that application, then the court will give you a reasonable allocation. Now, what must you prove? What must you prove when you make that application? You have to show that you're a dependent. Okay? You have to show that you are a person that is listed under Section 29. You are a dependent. Now, once you do that, then the court will consider the factors that are listed under Section 28. Number one, the nature and the amount of the deceased property. Okay, you are claiming that you have been left with nothing, or you've been given something that is not enough. Maybe everyone has been given 1 million and you'll be given 10,000. So what is the nature and extent of the deceased person's property? Was he a rich person? Any past, present, and future capital income from any source of the dependent. How are you surviving yourself? Do you have a job? Okay. Do you have a job? Are you doing well yourself on your own? Because if you're working, if you're doing better than all other beneficiaries, they don't need of you us giving you money. Okay. Any existing and future means and the needs of the dependent. Do you need anything now? Are you paying school fees? Do you need money for medical? What are your needs as a dependent? Whether the deceased person had made any advancement. Was this person, or did this person give you something when they were still alive? Because if you are given something when your father was still alive, it is just fair that you also let some people also get something, because you'd been given before your father passed on. And then E, very, very important. E is very, very important. The conduct of the dependent in relation to the deceased person. How are you relating to your husband? How are you relating to your father? How are you relating to your wife or to to your mother. Very, very important. If there's evidence that you are not a good spouse, you are not a good child, the court will not give you anything, because that will inform the reason why the deceased person did not leave you with anything. Okay, and then lastly is the situation and circumstances of the deceased or other dependents and beneficiaries under the will. What is the meaning of that? The meaning of that is we have to look at other dependents. Are they able to take care of themselves? If you're the richest of them all, why should we give you something? You don't need anything if you're the richest of them all. And then lastly is the general circumstances of the case, including as so far as can be ascertained, the testator's reasons for not making a provision for you. So sometimes the testator will indicate in the will, I don't want my daughter so and so to eat anything of mine. Let her go away. Or I don't want my son to be next to any property of mine. Let him go to the street and fend for himself. So we will look at the circumstances leading or reason why your father left you out. Okay? Those are the things that we will look at. So those factors are considered by the court. And then if the court is convinced, then we shall go to section 27. That is when the court will make an order. And that is the discretion in making an order. Okay? In making an order for the provision of a dependent, the court shall have complete discretion to order a specific share of the estate to be given to the dependent, or to make such other provisions by him by way of periodical payments or a lump sum, and to impose such conditions as the court may think fit. And you see this mostly in where the deceased person left behind maybe a spouse, and the spouse is now old, and now the children of the deceased person wants to take everything and leave their mother without nothing. The court will come in and say, no, from this estate, you're going to be paying your mother 100,000 every month. Okay, that is a reasonable provision. Or you're going to take 4 million shillings from this estate, you're going to deposit in your mother's bank account for our own survival. That is an order that the court can make. Or this land, and this one will be given to your mother. Okay, so the court can make an order that such provisions be made either by way of periodical payments or a lump sum, and to impose such conditions. Okay, or that a part of the estate be given to the deceased, sorry, to the beneficiary or the person that has made the application. That is how the court deals with provisions for dependents. So if you are a dependent and you are not happy, you've been left out of the will, you couldn't object. Objections are not part of this. This is not objection. If somebody has been left out of the will, or they've been left out of intestacy, they need to make an application for reasonable allocation, reasonable provision, adequate provision. Okay? Once they make that application, of course, before you make the application, there are two things to consider. The first thing is, are you a dependent? And if you're a dependent that needs to show maintenance, you have to bring evidence of maintenance. And then secondly is the grant been confirmed? If the grant has not been confirmed, you can proceed and make an application under section 26. If the grant has been confirmed, then hauna lako, the only thing you can do is section 76, that is the revocation of that grant. That is how you deal with dependents who have been left out, or who are claiming whether they can get anything from the will. Questions, please. Waire, Anthony, start with you.
Yes, Jackton. Mine was just an interesting one. If you don't make any provision in your will, say for your side chick or girlfriend, it will mean then that she'll get nothing. That she won't be able to seek any allocation under this section, right? I just wanted clarity on that one. Thanks.
You're very passionate. You're very passionate. Before I ban, are you next to your wife?
She's nearby, by the way. Kwa hivyo kuwa tu mpole.
All right, so I will not ban. No, I can feel how passionate you are about this topic, but it's fine. It's okay. It's life. But the thing is, side chicks are not dependent. They're not dependents at all. They're not dependent. They're not categorized anywhere, okay, as dependents. They're not, okay? And this goes to the side chicks. This goes to the side chicks, okay? If you are a side chick, there's nothing wrong with being that. But if you're a side chick and somebody, you are having an affair with someone, make sure that whatever they want to give you, let them give you now. Let them transfer to your name now. Get it now. If it is a piece of land, let them transfer the land to you now and have the title deed now. Let them give you the money now. Let you get the car now. When they die, you get nothing, okay? Because who are the dependents? A wife, former wife, children, okay? Number one. Number two, grandchildren, parents, grandparents, stepbrothers, stepsisters, and children that were being maintained, children that were taken in. So you have to be a child of that person, either born of him, adopted by him, or accepted into his family. So if you are a side chick, whatever that word means, you don't fall in anywhere in that category of being a beneficiary at all, or a dependent. So you can't go to court and say that this person was taking care of me. Even if he was taking care of you, even if he paid your rent today and he died tomorrow, you can't qualify to get anything from his estate. Why? You're not a dependent on that estate. So whatever it is, malizana na kesi, hakuna kesi baadaye. Malizana saa hii tu. Kama ni shamba nakwambia, oh, nitakuachia hii shamba, oh, nitakufanyia hivi, nitakubaia hii gari, unajua hii gari yangu wewe utabaki nayo. Hapana, hizo ni mchezo za town. We title saa hii, logbook saa hii, malipo ni hapa hapa. Sawa? So that is the thing. So my friend, side chicks don't get nothing at all. They are not recognized in the act. Tuko sawa?
Kabisa, kabisa.
All right. That is Anthony. Let's go to Omwenga.
Okay, thank you. Me, I was asking, why is it that once the grant has been granted, you cannot file an application for reasonable provision? And if the grant has been granted, under which rules will I present my case for revocation of the grant?
All right, we'll come there, but let me give you a good example why we can't apply for this application after the grant has been confirmed. Once the court has given a judgment, my microphone is on. Edward Yator, your microphone is on. So assuming that the court has given a judgment in a matter, in a civil matter, okay, or even in a criminal, you've been convicted already, judgment is out. Can you go to court and make an application maybe to introduce new evidence? You can't. So the reason is a grant is the final order of the court. It is a final decree and judgment. Okay? You cannot, nothing can come unless you are appealing against the judgment or you are reviewing the judgment. It's the same way when it comes to probate. The grant is the final order of the court, disposing that matter and closing the file. Okay? So if you have a problem, you first have to revoke or annul the grant. The grant must be revoked first, and then we can hear you. So that comes under section 76. But there will be grounds. There'll be grounds you have to show. For instance, if you are left out, the question is, why are you left out? If you're left out because your siblings lied that they were the only beneficiaries, then that is a ground for you to revoke the grant. And that ground is indicated as any false misrepresentation. Okay, so if the grant was made as a result of a false allegation or an untrue allegation, then that would be a ground to revoke it. So it was made to them because they lied that you are not there, but you are there. So that is a ground to revoke it. We'll talk about that when it comes to revocation. Are you together?
Yeah, thank you.
All right, let's go to Akiaga, Robert, and then Deborah, and then you can close. Robert Wakiaga. Deborah.
So mine is on election. I was wondering why the beneficiary under election has to give out a small token, yet the property belongs to him or her. So you see, under such an instance, you can easily invoke the doctrine of nemo dat quod non habet, because a testator can't, since the property doesn't belong to the testator, then he can't pass it to someone else, since he can't necessarily pass a good title because the property does not belong to him.
Very simple rule, very simple law. We just discussed it right now. I just discussed it in the last 2 seconds, and I've said, if you are my sister, you are given everything. Somebody's having the microphone on and a lot of noise. If you're given everything, if you're given the land that belongs to our father, and you're also given I'm given you a car. So it is okay. You're given the land that belongs to my father, well, in the will, perfect. I'm also given your car. You can come for your car. It is your car anyway. You can name that quote on a bed. Yes, you can come for the car. But remember, once you come for the car, I'm filing an application R26 to share that land with you. Because what am I telling the court? Hey, my father left me with nothing. Whatever was there was given to my sister Deborah under section 26. And because of that, that land that was given to you is going to be divided between the two of us. So to avoid that instance, because either way, I have to get something. The reason why you're giving me a token is because I have to get something anyway. So if you don't appease me by giving me something, because the rule is everybody should have something. Everyone should have something. So if you want to snatch me what I was given, then give me something. You can snatch me, yes, give me something. If you don't give me something, whatever was given to you, we are going to share it because it belonged to our father and you're given all of it. I'll go to court, tell the court, look here, my sister was given 10 acres, I was given nothing. Okay? Please, order of reasonable provisions, and then we will share it equally. Deborah, tuko sawa?
Yes.
Yeah. Robert Wakiaga, your microphone is not coming up.
Yes, Madam.
Yes, you can hear you now.
How do we make this application for reasonable provision? Is there a prescribed form? And two,
it is,
how
yes.
do we prove our being a dependent? Do we swear in an affidavit?
No, you don't. Unless it is this, some matters are taken, the court takes judicial notice, unless it is disputed. So if somebody dies today, and then you come to court and say, Your Honor, I'm also the son of this person, two things can happen. The family can say, oh, Robert, we know you, you are our brother, and then the matter proceeds that way, normally. Or they can say, oh, we don't know you. So once they say we don't know you, that is when you bring your birth certificate and say, I want a DNA. So you only prove if it is disputed, but some things are not disputable. Your brother is your brother. Unless you don't know them and you're doubting, that is when you will be doing the normal paternity and bringing evidence to show that you are also this person's a beneficiary. So unless it is disputed, if it is not disputed, you don't need to do any paternity or DNA test. Tuko sawa?
Thank you.
All right, sawa sawa. So guys, that is it for now. Unless there's another question, I want us to adjourn there. In the next class, we start with intestacy. But as we go through intestacy, we'll also go through the properties that are excluded. Properties excluded from the will, and that includes gift in contemplation of death, survivorship, and donatio motis causa. We start that in the next class as we go through the rules of intestacy. So rules of intestacy is a one touch. We discuss it in one class and it's done. And then we can start discuss the question of grants, or we can just look at a few past paper questions and then we start on grants. So don't worry about that. So that is that for now. Unless somebody has a question, I want us to adjourn the class. You guys have some time to prepare for whatever you need to prepare for today. Go wherever you're going, prepare for church or whatever. Go drink, and then I will see you guys tomorrow, same time, same place for civil. Not same time though, at normal time, 8:30 tomorrow. All right. All right. All right, guys, the recording has been stopped. I will share it, of course, as usual. Please ask for it